Okay, so you open the mail and there it is, that denial letter for your Jones Act benefits. It feels like the ground just dropped out from under you, right? The bills, they don't stop, but the support you were counting on just did. Well, this explainer is for you, for all the offshore workers in Texas and Louisiana who just need a calm, straight line to follow, a real plan starting right now.
You know, this quote, it just hits home. I just need the next move. A cook from Galveston said that, and man, does that sum it up. It's not about the legal jargon, it's not about the stress, it's about knowing what to do right now. So that's our goal here, to give you that next move, and the one after that.
And here's exactly how we're going to do it. This is our roadmap. We're going to walk through 6 clear, simple steps. We'll start with what just got denied, then we'll build the proof you need, cover your rights, and go all the way to that deadline you can't miss. This is how we're going to turn that anxiety into action.
Okay, first things first. Before you can even think about fighting a denial, you've got to be absolutely crystal clear on the 2 basic benefits you're owed as a seaman. They're called maintenance and cure. Let's break them down.
So, let's talk maintenance. The best way to think about this is it's for your basic living costs. We're talking about your share of the rent, your utilities, your groceries, the stuff you need to live while you're at home unable to work. This isn't some bonus or a favor. It's money they owe you.
And then there's cure. This one's pretty straightforward. It's your medical care. Doctor's visits, physical therapy, your prescriptions, the whole shebang. But here's the really crucial part. It lasts until your doctor says you've reached what's called maximum medical improvement, or MMI. It doesn't just stop because the company's insurance policy has some random limit.
All right, knowing your rights is one thing, but proving them, that's what actually gets you paid. So this is where you take back some control. We're going to build a simple but really powerful packet of evidence.
And this right here, this is the heart of the conflict. The company's going to offer you some low policy rate, right? Maybe 15, maybe $40 a day. But here's what you need to know. The law doesn't care about their policy. The law cares about your actual reasonable living costs. So that number on the right, that's the real number. That's the one that matters.
So how do you prove it? Easy. It's a 3-step checklist. Seriously, you can knock this out in 10 minutes. 1, calculate your real daily rate. 2, back it up with just 1 month of receipts for your rent, utilities, and food. And 3, get a quick note from your doctor about your medical status. That's it. Simple.
In fact, why wait? Let's do this right now. Pull out your phone, open up a new note, title it Budget with this month and year, and just snap a picture of your lease or mortgage statement, a light bill, and a grocery receipt. Boom. You've officially started building your case.
So you've started to gather your proof, which is great. Now, let's talk about the legal bedrock of your claim. We need to touch on what makes you a Jones Act seaman and, more importantly, the kind of leverage you have when a company wrongly denies your benefits. So, who is a seaman? You might be surprised. It has nothing to do with your job title. The courts have this rule of thumb. If you spend about 30% or more of your work time on a vessel that's in navigation, you probably qualify. It really just comes down to your time on the water. Now, this is huge. Your employer is taking a very real risk if they deny your claim without a good reason. If a court finds they were being willful or callous, like totally ignoring your doctor, they could get slammed with punitive damages or have to pay your attorney's fees. This gives you some serious leverage.
Okay, let's get into the weeds a bit. We're going to talk about the number 1 defense you're likely to hear. Oh, it's not our fault, it's because of a pre-existing condition. This is a specific tactic called the McCorpin defense, and we're going to show you exactly how to take it apart piece by piece.
This is the classic playbook move, right? You get hurt on the job, and all of a sudden, the company is blaming that old back thing you had 10 years ago that you forgot to tell them about. But listen, here's the most important thing to remember. The burden of proof is 100% on them. They have to prove it, not you. I look at this. The bar for them is incredibly high. To win with this defense, the company has to prove all 3 of these things. Not 1, not 2, all 3. First, that you intentionally hid something. Not that you forgot, but that you knowingly lied. Second, that this thing was so important, it would have been a deal breaker for hiring you. And third, that there's a direct medical line between that old issue and your injury today. If they can't prove even one of those points, their whole defense falls apart. Okay, Time for your next quick action item. Send a simple, polite email to HR right now. Just ask for a complete copy of all your pre-employment forms and physicals. This is the very paperwork they need to even try to make their case, so you absolutely need your own copy of it.
So, we've gone over your rights, we've got the evidence you need, and we know how to shut down their favorite defense. Now it's time to put it all together. We're going to take that 10-minute packet you built and turn it into an official demand for payment that they can't ignore. And this is it. These 3 short lines are pretty much all you need to say. It's direct, it's professional, and it's all based on facts. You're telling them what's attached, what you expect them to do, and you're putting the ball squarely in their court to justify in writing any reason for saying no. Seriously, take a picture of this, use these exact words.
Now, what if you send your demand and they still push back? You need to watch for these red flags. If they start ignoring your own doctor in favor of their guy, if they won't budge off that lowball policy rate, if they keep giving you the runaround, it's time to stop talking to them. It's time to call a lawyer who knows maritime law.
Okay, we're on our last section, and I can't stress this enough. This one is absolutely critical. All these rights and all these strategies we've talked about, they mean nothing if you miss your deadline to file a lawsuit. This 3-year clock is not a suggestion. It is a hard, unforgiving rule.
Just look at this timeline. For most Jones Act claims, that clock starts ticking the day you get hurt. And generally, you have 3 years from that day to file a lawsuit. There are no extensions and no excuses. You have to know your dates.
So let's lock those dates in right now. Grab a piece of paper, draw a straight line on it, mark the date of your injury, the date you first got medical treatment, and the date you got that denial letter. Then take a picture of it with your phone and save it. This simple little timeline protects the facts.
So, let's bring this all home. What's the big takeaway? Your goal here is not to start a war. Your goal is to package the facts so clearly, so professionally, that paying your benefits becomes the easiest path for the adjuster to take. You want to make saying yes the simplest box for them to check on their list.
And that's it. We're at the end. Your benefits have been denied, yes, but now your rights are clear. You have a plan. You know the steps. So the only real question left is this: is your 10-minute packet ready to send?